I appreciate Maria's time and efforts in helping make this happen today. So what we're going to cover today is we've got 50 minutes, right? This is meant to be a relatively short and sweet approach to getting your trainings in and getting a sense of what's out there. We are not looking to spend a lot of time talking about the loan servicing requirements or guidelines. This is meant to be a brief overview. We'll highlight what we call our top 10 list of the servicing requirements, but we're going to give you the sources so that you can look those up yourself. There's quite a few of them. The bulk of what we're trying to focus on here is we have asked folks in various emails over the last couple of months to escalate issues, to file complaints in certain ways, to send special violations to the Office of the Attorney General's office. And frankly, I was getting lost amongst these different emails, and I couldn't figure out which end was up. So I'm quite certain that others were getting lost as well. So this webinar is very strictly meant to parse out the differences and when do you file different escalations or complaints or violations and try to figure out the differences. So having said that, we're learning how to file the escalations, learning how to, or figuring out when to file the complaints, and then there are certain violations of the National Mortgage Settlement that the Attorney General's office has very specifically asked us to file and notify them of, and that's for loan modification timeline violations, certain ones, principal reduction violations, so the bank is not giving your client the reductions that you believe that they're entitled to, and refinance relief. On that, I'm going to ask Maria to take over.
Good morning, everybody. Again, my name is Maria with the Empire Justice Center here in Long Island. And the next slide here is the regulatory sources of servicing requirements. So as you probably all know, you can find the details of the National Mortgage Settlement on the website, nationalmortgagesettlement.com. And you can also find the over 300 servicing standard highlights there. So if you're on the website and you click on servicing standard highlights, you'll see these highlights. And I would suggest that if you haven't done so already, print these out and study these. This is your starting point to understand when a national mortgage settlement servicer is in violation of some of these standards: Citi, Chase, Bank of America, Wells, GMAC, Ally. And if you don't know the standards, you really won't know when there is a violation of one of the big five. Okay, the next website is the DFS website, and this is where you'll find the New York Servicing Guidelines issued by the Department of Financial Services and originally issued in 2010. This is what they're loosely called, New York Servicing Guidelines. Technically, they're Section 419 of the Business Conduct Rules. So this is the website for that, and the statutory authority on this is Banking Law Article 12D. Again, today we're going to refer to them correctly as the BCR. The BCR are servicing regulations. They're not just guidelines that apply to all properties in New York State that are secured by a mortgage, not just the big five servicers that the NMS covers. So if you have a borrower with a property in New York State and not one of the five servicers under the National Mortgage Settlement, the BCR regulations should apply to this. So why is this important for us to know? There's two reasons. The NMS is really a derivation of the BCR regulations. The BCR regulations have become a framework for what servicing standards and regulations should be. Secondly, the second reason is that servicing guidelines, again, apply to all properties in New York State under the BCR, not just the five servicers. So if it doesn't fall within the auspice of the NMS, it should fall within the DFS guidelines or regulations. And finally, the third website is the Consumer Finance Protection Bureau website. This is a federal agency. It's not just New York. And here, the regulations are broader. And if a servicer doesn't fall under the NMS or the BCR, it should fall under the guidelines of the CFPB, which was created in 2010 by Congress to protect consumers carrying out federal consumer financial laws. Okay, so let's look at what some of the standards are and how the NMS compares to the BCR. Becky and I put together a top 10 list. The top really NMS standards that are prone to violation. There are many more, but these are what we are hearing and seeing as really the most common violations from the grantees. So the first one under the NMS, a servicer must provide a single point of contact, also known as a SPOC. The banker servicer shall easily establish an accessible SPOC assigned to each homeowner who reaches out to the banker servicer. Their duties are to be one point of communication to explain the loss mitigation options, to coordinate document submissions, and to inform the homeowner or advocate of the status of the modification. They're supposed to ensure that the homeowner is considered for all options, and also they must have access, the ability to access those who can stop the foreclosure, such as a bank attorney. Now, if you compare that to the BCR does not require a single point of contact. They require adequate staffing to ensure that the borrowers are not required to submit multiple copies of documents, but does that really happen? The SPOC is a very powerful tool that we have under the NMS, and you should be reporting violations of it. There's a big difference there. The second servicing regulation is no dual tracking. A borrower who is pursuing a loan modification cannot be referred to foreclosure while that loan modification process is occurring. If the loan is pre-foreclosure and a banker servicer receives a complete loan modification application on or before day 120 of the delinquency, the servicer must review and make a determination of the application prior to referring the loan to foreclosure. If it's substantially complete but not quite, the bank must give an extra 10 days and then make their review. Now, if this is a post-foreclosure referral, which is once the loan has been referred to foreclosure, if the borrower submits a complete loan modification application within 30 days after the attorney letter is sent to the borrower, the bank or servicer must not move for a foreclosure judgment or seek a foreclosure sale until it has completed its review and determination of the application. If the servicer offers the borrower a loan modification, the servicer must continue to delay any action in the foreclosure proceeding until the borrower accepts or denies the offer. If the borrower accepts the offer, the foreclosure proceeding must be suspended unless the borrower fails to perform on the loan modification. These are very specific regulations and very important. By contrast, under the BCR, the guidelines are that it should avoid dual tracking, so that is a big difference. Number 3 on our top 10 list is under the NMS, the servicer must continue the loan modification processing and honor trial and permanent mods when the servicing of the loan is transferred to another servicer. So the second servicer has to honor a trial and a permanent mod. Under the NMS, at the time of the transfer or sale, the servicer shall inform the successor servicer if a loan mod is pending. Any contracts for sale or transfer must obligate the successor to accept and continue processing loan mod requests and honor these trial and permanent loan modification agreements. And when a servicer acquires the rights from another servicer, they will and they must continue processing the loan mods and honor the trials and permanent mods. Under the BCR, the only requirement is that the servicer should inform them about honoring trial and permanent mods. That's a huge difference. The fourth item on our top 10 list, under the NMS, the servicer must acknowledge receipt of a modification application within 3 days. The borrower advocate must receive written acknowledgement of receipt of a loan modification application within 3 business days of receipt. Under the BCR, the time frame is 10 days. Under the NMS, the servicer must notify the borrower or advocate of all missing documents or deficiencies in an application within 5 business days of receipt of the borrower's initial loan modification application. Under the BCR, it's 10 days. I know as advocates these are not happening, so keep this in mind when you're continuously submitting packages and not getting responses. Under number 6 of our top 10, the next one is the same under the NMS and BCR. The servicer must notify the homeowner or advocate of a decision on a loan mod package within 30 days of receipt of a full package. How often does that happen? Number 7 on our list. Under the NMS, the servicer must provide a loan modification if the loan passes the net present value NPV test. This is different than the BCR, which says it should provide a loan modification if it passes the NPV test. So there's really nothing that you can sink your teeth into that. Number 8, under the NMS, a servicer must provide denial of a loan modification with specific reasons. This notice shall contain the reason for the denial. If the modification is denied due to investor disallowance, the servicer shall disclose the name of the investor and summarize the reason for denial. If the denial is because it's net present value negative, the servicer shall provide in the denial notice the monthly gross income and property value utilized. Under the BCR, the requirements are that the notice must state with specificity the reason for determination, a contact person, and any other foreclosure and prevention alternative that they may be considered for. So we have seen denials that literally have an asterisk next to reason for denial is an asterisk. That is clearly a violation under the NMS. Number 9, the next on our top 10 list is adequate staffing. Under the NMS, a servicer shall maintain adequate staffing and have caseload limits. Under the BCR, the servicer must have adequate staffing to ensure that borrowers are not required to submit multiple copies of required documents during consideration for a loss mitt option. And finally, on our number 10 on our top 10 list, under the NMS, the servicer must comply with the Service Members Civil Relief Act and is entitled to a servicer employee that is especially trained on the SCRA. Please note that there's certain protections. Notify the servicer immediately that you're dealing with a service member. The SCRA was designed to protect service members against default judgments, mortgage foreclosures, evictions, and repossession of property, especially when they're in active duty. So there are many, many protections under the SCRA, under the NMS. So please, make sure that you are advocating properly for your borrowers that are in the military. There are many other servicing guideline highlights, such as forced place insurance, but please refer to the website for the rest of the violations, and please report them.
Okay, so I would like to point out quickly that the business conduct rules, if you are a servicer and you're servicing a loan that is attached to a house in New York State, right, then the BCR applies to you, to your mortgage, and how they service it. Having said that, there's no private right of action. So the best way to use the benefits of the business conduct rules is to use that as a sort of another link to support your claim that perhaps the lender is not negotiating in good faith. They're not following the guidelines. There's an industry standard and a requirement for them to follow these. You can use that as sort of another, like I said, a link or a plug, but it's not something that you can you don't have that private right of action, which makes the next couple of slides all the more important when we talk about the complaint procedures down the road. Okay, so changing gears slightly, we have the first, how we've sort of categorized these requests of our HOPP grantees over the last couple of months. The first one is escalations. And the escalations process is something that's been happening in New York City for quite some time. It's a fairly new process that's been spread to those of us in upstate as a result of the HOPP funding. And so we encourage folks to utilize them. There's two methods, and it depends on whether you're a housing counselor or whether you are an attorney representing somebody in the settlement conference process or is in litigation. But if you're a housing counselor, or if your case is not in litigation and your rules of ethics do not bind you or prohibit you from asking a third party to interfere and talk to opposing party, then you can escalate these to Jadeo Johnson at Center for New York City Neighborhoods. If you are in the settlement conference process, or as I said, the ethical rules do not allow you to get somebody else involved, you can escalate to Adam Cohen. In these escalations, you're looking for an individual response. This is not something where you send it off and then it goes into space and you never hear of anything further again. This is something where you need somebody to intervene and help you move the case further down the road. And we'll explain how in a moment. The other thing is based upon a conversation I had with another attorney in the state about in-house escalations or appeals. We use the same terminology. It's a slightly different bird, but the in-house escalations is something that is we've been given an opportunity through the use of the NMS and the BCR and different methods of raising the issues that you're seeing with your homeowners within the bank itself. And you can pursue both the escalations to the New York-based escalation systems, and you can also do the in-house bank in-house escalation systems. My recommendation is probably to do the in-house escalations first. If that's a dead end, then you go to the Center for New York City Neighborhoods or Adam at the Attorney General's office. Okay, so when do you escalate? I've started to talk about this. Basically, when you're getting the runaround from the bank, you can read through some of these, the reasons or some of the circumstances that you might want to do it. But primarily, it's when if your lender were adhering to their servicing requirements, you wouldn't be getting the runaround, right? So if they're adhering to the timelines, or if they were answering your questions and giving you a consistent answer, you would be able to have an effective level of communication with the bank to figure out a way to resolve your client's issues in whatever form that takes. But they're not doing that. Those are the times that you should be thinking about escalating to these third parties, the New York-based third parties. Let me say one more thing. When you are looking to escalate, these are not the cases that you're escalating that it's hopeless, right? So you have somebody who is completely upside down. There's no hope. Their finances don't support a payment at all. The bank has followed all of the servicing rules and requirements. They've given you a legitimate answer that makes sense, that it's a fair answer, and the answer is still no. Those are not the kinds of cases that you need to be escalating. That's just simply, it's not going to work out for the client, and you need to talk about other ways to either dispose of the property or other methods, other strategies. I hope that's clear. Okay, so here's the form to escalate to the Center for New York City Neighborhoods. There have been lots of emails out there that provide a whole lot more detail than what we're going to provide in this webinar. But hopefully this will jog your memory a bit. If you have specific questions, refer back to those webinars or those emails. If you can't find them, contact your regional coordinator. We're happy to re-forward them to you to get the details. This is meant to be an overview of how do you parse out when you complain and escalate or whatnot. Here's the form. If you are complaining to the Office of the Attorney General's office, essentially it is the same form that they have on their website for any complaint that you want to send to Consumer Frauds and Protection Bureau. The difference is that you can send this directly to Adam Cohen, and he will do what he can. So when do you escalate or appeal within the servicer? So again, it goes back to what the servicing requirements or the BCR allows for. So according to the National Mortgage Settlement, you can appeal it within a decision within 30 days of the denial, which we encourage you to do so. And you can appeal if the denial was for an NPV failure and the property value is wrong. And to be clear on that, if you find that out, which I encourage everybody to confirm the data points that they're putting in. If you get a denial, you want to make sure that there's not any human error that's coming up with a wrong answer with the calculation. So the borrower, if the property value that they're using is simply wrong and you believe it's something lower or higher or whatnot, the borrower can pay for their own appraisal, and then the bank is required under the NMS to use that value for the new NPV test. And according to the business conduct rules, you can escalate anytime you have a disagreement with the servicer about eligibility for borrower loss mitigation options. So it's quite broad. So that's escalations, right? That's, you're going to get a personal response about your client's, your borrower's issues. Now we have complaints where it's you're sending it out there and you're alerting the authorities, so to speak, of these problems. And there's numerous ways to do that. the first way, and it depends on what it is that they're violating, and as a result, who's monitoring those regulations. So the Office of the Attorney General's office, if there's a violation of the national mortgage settlement requirements, you have to report them in your data report that we all love. So every 2 months you have that opportunity, and it's a required field for you to fill in. We know it's happening. We're not seeing as many complaints as we believe are actually happening out there, so we encourage folks to pay special attention to that data field when you're submitting them every couple months. If you so choose, the HOPP grantees may file a written complaint to the Office of the Attorney General's office. But again, we use that in my practice. We use that when we have clients that are particularly miffed about how things are going, or frankly, we're just so irritated that we want to make sure that everybody who should know can know that there's something wrong and that this bank is giving us the runaround, and we'll file it with everybody we can think of. Then there's the National Monitor. It's another location for you to file NMS servicing requirements violations. You should expect, or there should be no expectation at all, that any of these 4 agencies talk to one another. So if you feel like, well, I'm submitting it to the Office of the Attorney General's office, that somehow the National Monitor is going to get wind of that, that is not a realistic expectation. And the next one is the Department of Financial Services. That's for violations of the New York Business Conduct Rules. I think that in some ways is very, very important because we don't have a private right of action, the Department of Financial Services needs to be aware that their guidelines, their rules are not being adhered to. And then finally, the CFPB violations of the CFPB mortgage servicing guidelines. And when you're looking at these slides, you should be aware that the most detailed level of servicing requirements is coming from the NMS. Department of Financial Services, the Business Conduct Rules is more vague, and quite frankly, the CFPB is probably the vaguest and the broadest coverage. Okay, so here's your forms. Your primary form to complain to the Office of the Attorney General's office is your data fields, your data points, every 2 months. And then here's the optional form. And this is a specific form that was created to deal with the NMS complaints and issues. You've probably seen this form. If you have not, you know who to call. And here's the website. Literally, I copied and pasted the website that we put in the previous slides, and I gave you a screenshot of it. Same thing here. Here's the Department of Financial Services website. You'll know that you're at the right spot when you see this page. And here's the CFPB. Okay, so all right. So violations of the NMS. There are some violations that the Attorney General is particularly interested in knowing about. And they fall into sort of 3 categories. The first one that I'm going to cover is the modification timelines. Maria's going to cover the next 2. So they've been asking since about the end of February to submit over the next 2 months. So technically it ends at the end of this month, but they are accepting additional violations into May. So they're looking to focus in on Bank of America and Wells Fargo with very specific timeline violations. You submit them to Dina Levy, and you should be completing the special form that was created, this NMS timeline complaint form. And then as lawyers, you know how this works. If you have a complaint or if you have a violation, as best you can provide supporting documentation for that. So whether that's a letter from the bank indicating, you know, timeline problems, that's very helpful. If you have whatever you have, submit as much as you can. So here's the form. Hopefully people are aware of it. So far the complaints have been rolling in, the violations or whatever. And the Attorney General has been very happy. They're hoping to get more, and then they're going to be submitting that to Eric Schneiderman and to, I believe, the National Monitor once this is all said and done. Did I? Sorry. Go ahead.
Oh, back one.
There we go.
Right there. Okay.
Thank you.
Thanks, Becky. Thanks, Becky. Okay, so violations of the National Mortgage Settlement principal write-downs, or also known as principal reductions, or violations of the NMS Refinances. The Office of Attorney General, as you can see, is interested in borrowers who may be eligible for this relief under the NMS, but who have not been solicited. So what does this mean? Well, when a borrower should be considered for a principal write-down or a principal reduction, but they have not been solicited, they should be reported to the Attorney General's office. So where do you submit them? You see Dina Levy's email address there, the Office of the Attorney General. Dina Levy is Special Assistant to the Attorney General. And what should you submit? The borrower name, loan number, the borrower zip code, and your contact information. Becky is going to go through a form that also you should be submitting when you are reporting violations of the NMS principal write-down or principal reduction. So when do you submit these violations? Well, your borrower must conform with all of these points. First of all, they must be 30 days or more delinquent or at an imminent risk of default because of the borrower's financial situation. The pre-modification loan-to-value ratio must be greater than 100%, which means that they're underwater. Basically, the house value is less than the mortgage amount. Perhaps the mortgage is $250,000 and the value of the house at this time is $200,000. The post-modification payment should target a debt-to-income ratio of 31%, and it is not an FHA or a GSE-held loan, which is Fannie Mae or Freddie Mac. So your borrower must conform to all of those 4 points in order to be considered for an NMS principal reduction. If they are and they haven't been considered, please report that and let Dina know about it. Okay, so the second violation that I'm going to talk about is the violation of the NMS Refinances. And that, too, has some requirements that you have to look for when you are submitting this to Dina. Also to Dina Levy with the same requirements. It must be an owner-occupied property. The loan must have been originated before 2009. They must be current with no delinquencies in the last 12 months. The loan-to-value must be over 100%. Again, if the borrower is underwater. And it's only for first lien loans owned by the servicer. It cannot be FHA, Fannie Mae or Freddie Mac held. The interest rate must currently be 5.25% or higher. There must be no modification in the past 24 months, and they've not been through foreclosure or bankruptcy within the past 24 months. So if your borrower falls into all of these categories, it's not an or, it's an and. They must comply with all of these. Please submit that, and they may be eligible for an NMS refinance.
Okay, so here's the form that you should be submitting for violations of the refinance or the principal write-down. And since we do have a little bit of time, I'm going to show you, oops, I can get into it. I'm going to show you a little trick that I think is going to answer, I think we have Derek Tarson is asking where do we get these forms. There's a couple of ways that you can do that. The first way is Michelle has sent you those forms in the invite for the webinar. In addition, darn it, you have been sent the actual PowerPoint presentation, and I'm not sure whether it matters if you have an older version of PowerPoint or not, but bear with me as I show you a little trick. I have embedded the documents into the PowerPoint presentation itself. So if you know me, you know that this is a very big, important moment in my life to figure this out technologically wise. So I think I'm just going to brag a bit and show you the benefits of it. So if you go into the Create view in the PowerPoint presentation, you will be able to click on these actual forms and fill them out from the presentation itself. So click on the forms. Let's go to slide 21, right? You click on the actual document once, and then you double-click it. You can see my little thing, my cursor thinking. You can see how technologically advanced I am when I call it thinking. Hopefully this will work. Lovely. All right, so all I've done is clicked on it, and now you can actually fill out the form. Right, you see it? And so you'll slide down, you can see the 2-3 pages here. This third page is where you're going to fill in the segment about refinances and principal write-down. So you would click Other, and then you would type in here whatever you wanted. And then you can print this out and save it or do whatever you want with it, and you don't have to do anything other than go into the PowerPoint presentation. So there we are.
I would just suggest if when you're filling out in the box that Becky just showed you so eloquently, that you list all the points that we went over today. So your borrower conforms to all those 4 points under the principal reduction requirements of the NMS, or all of the 1, 2, 3, 4, 5, 6, 7, 8, 9 points under the NMS Refinance, and just make it as detailed as you can, and any documentation that can support it, I'm sure they would appreciate.
Great. Okay, so at this point we're going to open up for questions. We have the one from Derek, which I believe I've answered. Hopefully that answers it for you. They're also on the Office of the Attorney General's website, I believe. And there's also various emails that have come back and forth. If you can't find it, or if you want the original emails, like I said, reach back out to your regional coordinators, and we will send those to you again. One of the questions Rosemary Roberts has asked, are you interested in complaints or escalating related to any of the big 5 servicers that have to do with mortgages that don't fall under the NMS coverage, i.e. FHA or GSE loan? Okay, so if you are a servicer, if you're one of the 5 servicers, you're covered by the servicing guidelines. It doesn't matter who owns your loan in terms of the national mortgage settlement. What matters is who's servicing it. And that's, different depending on what you're looking at. But strictly for the NMS, if your loan is serviced by Bank of America or Wells Fargo, and they're violating the terms of this, if they're violating the servicing requirements, that's a violation. It doesn't matter who owns the loan. I don't see any other texted or chatted questions. Michelle, is this something that, can we open up the lines in case people want to ask questions on the phone?
I'm just scrolling through all of our attendees, and it looks like most of them are listening through their computers. I don't think, unless you're on the telephone and you use the telephone audio option, you can raise your hand and I can unmute you if you have a question. But also for everyone that's listening, the CLE code for today is going to be R as in Robert, E as in Edward, 492.
Okay, great. Maria, we have a question about the difference between the dual tracking between national mortgage settlement and the business conduct rules. Can you go through that again, or with a little bit more detail?
Okay.
Do you see that question?
No. Let me see.
Okay.
I can't see it.
All right. I'll just read it out loud. It says NMS versus BCR, no dual tracking. Kindly repeat shall not versus shall avoid difference.
Shall avoid it's really under the BCR. It's not specific that you do not, there is no dual tracking that is of any type of violation of the BCR regulation. It says that it shall avoid. Where is it? Okay. And under the NMS, it's a regulation that it must be conformed to. I don't know, Becky, if you want to.
Yeah, the bottom line is that is more vague, and it's, if you're looking at these violations, if you have an NMS violation, you have a bigger stick, frankly, because there's no wiggle room for these servicers. They have to abide by that requirement. They're not supposed to be doing this dual tracking. Under BSR, that's covering anybody that's servicing in New York, but there's not as high of a level of protection for homeowners if you're not covered by the NMS. So as we said, you shall avoid it, but there's no strict requirement that they have to avoid dual tracking if you are not one of the 5 servicers. Hopefully that answers. Okay, and then it says, go ahead.
I'm sorry. Were you done?
Yeah, go ahead. I was going to go to the next question.
Oh, okay. I do have somebody that raised their hand. Derek Tarson. I'm going to unmute you.
Hi.
Can you hear us?
Yes, I can hear you. Can you hear me?
Yes.
Okay. I actually posted my question on the chat, but it's probably easier for me just to say it. Back on slide 19, we have this post-modification payment should target a DTI ratio of 31%. Now, what does that assume that can be done in order to get to 31%? Does that include lowering the interest to 2% and extending out to 40 years and a principal reduction, or just a few of those?
It's assuming following the waterfall, right? So first you're trying to you lower the interest rate as far as you can down to 2%, and then you extend the term, and then the next step is the principal reduction. So you shoot for that 31%. If you can attain a 31% by reducing the principal to a limited extent, then that's when you're raising it. If you can't get to that 31% by doing all 3, by raising it to the 2%, dropping it to the 2% and extending it out, then that's where that's an opportunity to raise it as an issue, as a question.
Okay. If the are we limited to principal reductions of 30% only, which is under HAMP, or are we going to a principal reduction that would actually reflect the value of the property?
You know what? I'm not an expert on that. I think that it's limited to HAMP, but I don't want to say that that's true because I'm not 100%. Maria, do you know that off the top of your head?
No, we can get back to you on that question. That's a good question.
Okay. All right.
Yeah, I'm sorry. Okay. So here we go. So when we state a mortgage is held by a GSE, you mean owned, not guaranteed, right? What happens if a loan is guaranteed by a GSE, and how do you know if it is? This is an area of at this point I should know the answer better than I do, and this part always makes me queasy when we talk about the differences. So I'm going to be smart and not answer that question, and I will take that down, and I will find the correct answer because I get myself lost in that, to be quite frank with you, and I'm sorry. Maria, do you have a better answer than my ignorance here?
No, it's a very technical. We want to make sure we answer it properly. It's very technical, so we can get back to you on that as well.
I believe that it does. First of all, that when we say the mortgage is held by GSE, I do believe I am misspeaking, and it is owned. But again, I don't want to claim any sort of expert level on that. I will get back to you on that. Do we have Carol Richmond? Michelle, do we have the contact information for?
Yes, we do.
Okay, great. My apologies on that. Anybody else have any questions that hopefully I can answer, or at least kick it down the field for a couple of days? Okay, great. Well, we're finishing up a bit early. I hope that that's okay. If you have other questions going down the road, let us know. Hopefully this was helpful to you, or at least clarifying where you should be starting with some of these issues. And we appreciate your time.
Thank you all for joining.
Yes, thank you.
Okay,
And we will get back to you on the answers to your questions. We'd rather get you a proper answer than misspeak.
Okay, and the final reminder to everyone, thanks again for joining us today, and to complete the registration, the evaluation that you're going to be sent at the end of the webinar today. And because of the fact that we are ending early, if you've requested CLE credit, it'll be a half a credit, not a full credit because of the time. So hopefully that's not a problem. and we'll get those CLE certificates and the certificate of attendance out to folks within 30 days.
Okay, great.
Okay?
Thanks, everyone.